First, though, we have a panel from the Solomon Islands who will be presenting on and discussing the Family Protection Act with a focus on access to justice for women living in rural and remote areas, which has been a theme throughout the symposium today. We are very grateful to you to participate today, given the recent unrest in Honiara. We have a very esteemed panel of women. We have Miss Vaela Ngai, I hope I'm pronouncing her name correctly, who is the Director of the Women's Development Division at the Ministry for Women, Youth, Children and Family Affairs. We also have Koisau Sade, who is the Senior Policy Officer in the same division. And they'll be joined by Ms. Ruby Awa, who is the former Project Manager for the Pacific Communities Regional Rights Resource Team Access to Justice Project. This session will run for 50 minutes, and I'll now hand over to Ms. Vaela Ngai.
Greetings from Solomon Islands. I think I first of all like to take this opportunity to thank SPC and ANU for giving Solomon Islands the opportunity to also share our experiences in the implementation of our Family Protection Act, particularly the implementation of our protection orders established under our Act. I hope our slide is up. If you can see our slide. So the Family Protection Act, the Solomon Islands Family Protection Act was passed in Parliament in 2014 and enforced in 2016. And so really have only had, I guess, 4 years of implementation or enforcement. So essentially, it's still a very new act for us. However, the key objectives of the act, for the first time for Solomon Islands, it criminalizes domestic violence and also establishes other offenses. It looks to ensure protection for victims or survivors of domestic violence, especially through establishing 2 key protection mechanisms, the police safety notices and the protection order. Also, one of its key objectives was to ensure support services are available for survivors, particularly strengthening referral pathways between, service provider or service providing organizations. Just briefly on the 2 key protection mechanisms, the police safety notice and the protection order. The police safety notice can only be issued and served by the police. It lasts for 21 days, which can also be extended for a further 21 days. It allows for survivors to also request additional conditions to the notice, apart from 2 mandatory conditions, which is not to commit domestic violence or to have possession of a weapon. The police safety notice is effective once it's filed in court, and through the police safety notice, once it's served by the police, a police officer must also assist the survivor to apply for a protection order within the 21-day period. And breach of the police safety notice is also a criminal offense. In terms of the protection order, as I said, we have 2 types. One is the temporary or the interim protection order that a survivor can apply for, in the process of getting a final protection order. The protection order can be, applied for by the survivor or by another person on their behalf. especially in the case of, other vulnerable groups such as children or, people with disability. The Interim Protection Order, or IPO, the period that it remains effective, it ends when either it is revoked or when a Family Protection Act order is granted. And the final protection order can last up to 5 years. The IPO, or the Interim Protection Order, can be issued by magistrates and authorized justices, which my other colleague will speak to shortly. And the final protection order can only be issued by a magistrate. And of course, the breach of the protection order is also a criminal offense under our Act. I'd like to hand over to the next panelist.
Hi, good afternoon. So I'll be talking a bit about a project of SBC in Solomon Islands. So the name of the project is Access to Justice. First of all, I think I must say that the Access to Justice, so the project was originally an SBC project that was funded by the United Nations Trust Fund and the Australian government bilateral aid to Solomon Islands. The technical support was by SBC, but although the project itself has ended, the project design and the project objectives are continuing under the Ministry of Justice and Legal Affairs and the Ministry of Women, Youth and Family Affairs of Solomon Islands. So this is about a project that was rolled out from 2017 to 2020. Sorry, I'm still not, yep, this slide. So the project was from 2017 to 2020, but it is still continuing. Now, basically, what is this project about? I'll start with a provision in the Solomon Islands Family Protection Act, and this is similar to the Vanuatu Authorized Persons mechanism that we've heard about earlier. So under Section 17 and Section 9 of the Family Protection Act of Solomon Islands, there is a mechanism that's established. It's quasi-judicial, part of it. So this mechanism, they're called authorized justices. Now, authorized justices have powers to issue interim protection orders. Who are these authorized justices? Section 9 of the Act sets out that there are 2 categories. The first category is they are justices of the local courts, and the second category is prescribed persons. So basically persons of good standing in the community. And for the local court justices, they are part or established under the Local Courts Act of Solomon Islands. And basically who are local court justices? They are our traditional chiefs, and they had a role to provide and hear land disputes, and they've had that role since 1959. Under the Local Courts Act of Solomon Islands, the Chief Justice has powers to give the local court justices, who traditionally have always sat and listened to land dispute cases. The Chief Justice has powers to give them other jurisdictions, and one of those is to issue interim protection orders under the Family Protection Act. I will talk about the second category, prescribed persons, during the course of my presentation. So these authorized justices, they're based in villages. So basically they are traditional leaders in villages. In order for someone to become part of the local court, they have to show that they are recognized as chiefs in their villages. And of course that translates into majority of the people, the target audience that the project worked with were men. There were about 44 men and 2 women. Initially, at the end of the project, that number increased with some 36 women added on and trained to do duties as authorized justices, but become prescribed persons along the way. So these people are villagers. Before I go into the training and the deliverables, I'd like to step back a little bit about the family protection or the protection orders under the Family Protection Act of Solomon Islands, because there's a slight distinction with other countries around the Pacific. Now for Solomon Islands, the application for a protection order is for a final protection order. So when it's like in civil law, you apply for a civil remedy, and then in the course of that, you can apply for an interim order in the course of that. So that's the relationship between the final protection order and the interim protection order for Solomon Islands. In essence, the application for protection order is, at the first instance, for a final protection order. Now, the Act says that for certain instances, that application for that remedy can start with an interim protection order. So the role of the authorized justices is part and parcel of this remedy that really comes under the jurisdiction of the magistrate's court. So basically, the authorized justices, they start the process, and it's part of an ongoing process that is disposed of or ends at the magistrate's court level. Now, what that means is the interim protection order, it does not have an end date. It doesn't end in 21 days or 3 months. It ends with events. So the two key events, the interim protection order will end if a final protection order is issued or not issued. So basically the magistrate's court case comes to an end. Or it will end where there is a revocation. So either the respondent or the affected person, that's what the Act calls the claimant or the applicant. If they apply for the order to be revoked, then the authorized justice or the courts can revoke the interim protection order. So just to start off with that distinction, that the interim protection orders or the IPOs in Solomon Islands are part and parcel of the bigger remedy, which is the family final protection order. Now, when there is an application for an interim protection order to an authorized justice or to the court, just like other countries, the order can be made, the application and the order can be made ex parte outside of ordinary business hours. And if the court, the magistrate court or the authorized justice is satisfied that there is likelihood, there has been domestic violence or there is likelihood of domestic violence, the person has no available remedy, or there is a need for protection from further domestic violence, then they can issue the interim protection order. The other point I'd like to also talk about as well is in terms of the standard of proof. So a protection order effectively is a civil remedy. The authorized justices, or we call them the AJs for short, they are effectively chiefs. They are local chiefs. They're based in villages. They are unlikely to have gone through law school or to carry out, have been to any training on the law previous to their being awarded, their position as an authorized justice, and going through the trainings under the project. In terms of the standard of proof, there's a distinct difference for the standard of proof for authorized for an IPO and the standard of proof for a final protection order. So for the IPO, the law sets out under Section 20, subsection 3, that the standard of proof is what is considered sufficient and appropriate given the temporary nature of the order. And for the final protection order, it's the civil standard of proof, which is on a balance of probabilities. So when the AJs are listening to a case, through the training they carry out, the training builds their capacity so that when they're they're telling the stories when they're looking at the evidence. They are looking at what they consider sufficient and appropriate, or whether or not there has been domestic violence. The other issue as well is in terms of, because it's a continuous matter that effectively will end at the magistrate's court level, that also means that we have to be careful in Solomon Islands so that even at the local courts level, the evidence and how it's taken is admissible, and it can be defended when it goes up to the magistrate's court. What we don't want is someone goes up to the magistrate's court and a survivor who's a woman who's traveled, walked for 3 hours, and they realize that it's inadmissible evidence and they don't have the protection that's there because of a technicality. Now in Solomon Islands, as is the case in other Pacific countries, the evidence can be submitted or admitted to the court as sworn statements, or it can be taken under oath, where a person stands in the dock, usually in the courtroom, and they swear on the Bible to tell the truth and nothing but the truth. Now, if you have a villager that's in a village 6 hours, 3 days away from a court, that's something that when we do the trainings, we have to also train the authorized justices to be careful with that. So before they take the stories, if the affected person is unable to write down their story in the application form, then before they take the story, the authorized justice has to make sure that they get the person to make an oath, and then the story that's told and filled into the form, which is the application form, will become admissible evidence because it's stories that are taken under oath. Of course, for the magistrate's court, they have both, so they can have, if there are lawyers involved, then there's a sworn statement. Otherwise, they can put a person on the stand and say that what they have in their form 2 is, and they can swear on that is the truth. So in the process, the process where it starts with the authorized justice, eventually after the police have the responsibility to serve the interim protection orders. And as part of their responsibility, their statutory duty, after they serve the order, then they have to go and file it in court. So then it begins the process for the magistrate's court to then pick it up for review for the final protection order. Another issue is when because it starts at the village level. It starts with the authorized justices who are accessible to people at the community level. But when the case goes up to the magistrate's court, you have a final protection order. It's actually a hearing, and when there is a hearing, there's 2 parties, and we have, I think other countries call them legal aid. We call it the public solicitor's office, where they have a duty to provide free legal support for the public. A lot of their work is defending criminal matters, and we have a unit within that's called the Family Protection Unit. Unfortunately, even with that unit, they go by their mandatory duty under their, I guess, their legislation and their policies, where it's a first come, first served basis. So practically what happens is you have a woman who applies for a protection order, but then when they get up to court, you are likely to, the men are the ones who are likely to get the lawyer, because the public solicitor's office most of the time are the defenders, the public defenders, and it's also first come, first served basis. So, once they get served with an order, they run there, they get the lawyer that defends them. The family protection, the family support center, they have a legal unit. They are, apart from private lawyers who are not that accessible for a lot of women, they're the only ones that are likely to be representing the affected persons or the survivors. So then we have a scenario where when you have a full hearing, just like any other case, there is also cross-examination that's likely to happen, and that really puts the survivors at a disadvantage. So there's a lot of awareness, a lot of information, a lot of support that we are also working on. Now, the idea of authorized justices, who are local court justices and prescribed persons, so there's two categories. This idea came about because of the nature of where Solomon Islanders live. So 80% of our population are in not just rural, but they're in remote rural areas. That means it's quite difficult with unscheduled transportation to get to those areas. So, but we do have we have chiefs and we have local court justices that have been established since 1959 that are spread out in a lot of the villages. So we have that mechanism, and what it is giving that mechanism where you have the custodians of peace, those who look after the law, giving them that extra duty to issue the interim protection orders. Now, the local court justices, they are established under the Local Courts Act, and the Chief Justice under the Family Protection Act gave them the special jurisdiction. Coming back to the project, so basically what the project did is we have these people who are in the communities who really know their custom, but we need them to be gender sensitized. We need them to understand the Family Protection Act, and we also need them to be familiar with some legal procedures and something, so that once the story goes through, the protection is solid for the survivor. So basically the project, the key objective is to ensure that women survivors of domestic violence have access to protection, and the authorized justices are part of the protection mechanisms under the Act. And so there were, it's a pilot project, so we worked in 2 provinces, Malaita province and Guadalcanal provinces, in 37 sites, which most of them are quite remote, and built the capacity of authorized justices. And I think after the 3rd year, we also worked with prescribed persons, and also worked with a number of what we call community facilitators. Basically, you have this mechanism in the community, the people need to know about it. So there's got to be increased awareness about the Family Protection Act, about the protection orders, of course, about the criminality of domestic violence, and most importantly, that now you have these people who are already in our community who can provide the protection order. So the project for 3 years trained the authorized justices to do their duties under the Family Protection Act, to issue the interim protection orders, and also worked with community facilitators to disseminate information that there is this protection mechanism that you can access without traveling for 3 days in a boat or spending money, which is it's unaffordable for most in the provinces. Now, I guess another thing I need to talk about is the service of protection orders. So protection orders only become effective, like in other countries, where the police serve the orders. Now, the police in our law is any police. So we do have family violence units, and a lot of police stations, they have specialized offices for their family violence unit, but the Family Protection Act specifically says just police officer. So basically the frontline officer, up to whoever is the person looking after the police station, any police officer can issue the interim protection order. The other thing is, because of our civil rules, if the order is not served after 3 months, then it becomes null and void. But once the order is served, then it runs until the matter is reviewed by the magistrate's court for a family protection order, or there is a revocation. Now, in terms of the training that was carried out for the authorized justices, we were very conscious that these were men, and under their watch, Solomon Islands had 2/3 of women between the ages of 15 and 49, or about 64% who experienced intimate partner violence. So that means under their watch, we had high tolerance of domestic violence. We also had low reporting, so that also points to the fact that there is likely high tolerance of domestic violence and justification by these chiefs, because that's the basis that we start from. And it was a tough call, but to begin with, these are influential people in the community. So what we did was we targeted, so we had to train them, and also we made recommendations for the courts to cut out who did not or could not change their mindset to be gender sensitized or to see domestic violence as wrong. Unfortunately, in our experience, a good majority, when they learned that it's wrong, when they saw the effects of it, when they saw the causes of it, then they were able to change their messages and went on to be good champions for domestic violence in the community. So the trainings, they covered a lot of, I guess, concepts. So there's two parts to it. One is the concepts part, or what's the abstract one, where they learned about gender inequality, looked at that as a core concept or cause of domestic violence, looked at the link between gender inequality and domestic violence, looked at the human rights-based approach, learned about the definition of domestic violence as set out under the Act, look at themselves, principles that if you become unauthorized justice, you have to follow those principles. And also looked at the protocols for responding to a survivor of domestic violence. So you find a private place, you assure them of their confidentiality and privacy of the information they will share, do a risk assessment, safety planning, and of course, how to do referrals, how to set up a referral within their own community. So that was part of the trainings, and the second part of the training is on how to fill in forms. So that's gone on for 3 years in Guadalcanal and Malaita. And with SPC, UN Women has also come on board to support with passing on or mentoring staff from the government offices, so the local courts, the Ministry of Women, Youth, Children and Family Affairs, and the Ministry of Justice and Legal Affairs, so that although the project has ended, this goes back, and the administration of the Act is with the two ministries. So the staff are now rolling out the trainings with other provinces. So although the project started with 2 provinces, thank you to SPC, we are going to roll it out with our SafeNet, that's our referral system, to all the communities, all the provinces in Solomon Islands. So that's a bit about authorized justices, IPOs in the project that I used to work on. Thank you.
Okay, thank you very much, moderator and fellow panelists. Can you hear me?
Yes, we can.
Okay. So the next couple of slides, I will take us through them, and it's mainly on the statistics and the trends of the mechanisms under the Family Protection Act. So this first slide it shows the protection mechanisms under the Act and how they have been applied in the first 3 years of implementation from 2016 to 2019. So as you can see, the domestic violence cases reported, these were reported to the police. It's about 3,839 cases. It's also important to note that the police are only one service provider under the under the SafeNet referral system, in which other services under the SafeNet service providers also receive different domestic violence cases, but there are some survivors that may opt not to report to police. Importantly, you can see a substantially higher number of people reporting domestic violence to police as compared to those receiving protection through the police safety notice or a protection order. There is a very high rate of attrition. We can see the numbers are dropping very low. And at the end, we can see, like, out of the 3,839 DV cases, only 13 have resulted in protection orders being issued. And we can see that police safety notice were the most preferred protection mechanisms. However, most police safety notices did not get filed to court, and these were rendered ineffective. So we have more work required to ensure that the PSNs are filed in court. Next slide, please. Thank you. So this graph shows the key trends similar to the previous one, but this one is separating to the different years. So the top line we can see shows the number of reported cases, and the highest was in 2017 at 1,706 cases, and decreasing to 447 by 2019. So during that time frame, there was also a small drop in the number of police safety notices issued, and a slight increase at the end of 2019 in Family Protection Act criminal cases brought to court. Okay, between 2016 and 2019, there were 140 interim protection orders issued compared to the final protection orders, 13 of them. This could have meant that many court cases are still pending, or that application was withdrawn, or the interim protection order may have been revoked. So in Solomon Islands context, overwhelmingly, women report that they would like to remain in their relationship, but just want the violence to end. The lack of uptake of the final protection orders could be related to a preference for temporary measures such as the police safety notices and interim protection orders. Women have reported that the PSNs have been effective at interrupting the violence, and therefore there is no need to continue to pursue a protection order. However, there are also reports that some women continue to seek multiple police safety notices. It is likely that women are not being given the adequate information or are receiving the support they need to apply for the longer term protection of a protection order. Yes, thank you. So that is the key trends and the statistics on the protection mechanisms under the Solomon Islands Family Protection Act. Next panelist, please.
Thank you, Koisau. So can you hear me?
Yes.
Yeah, okay. So in this slide, I'll quickly just run through some of the key challenges in terms of the implementation of the protection orders. And, you know, it kind of also brings out some of already the, you know, as challenges, the different aspects that has been mentioned by the two previous panelists. I've highlighted 4 here. The first one of the key challenges, definitely, as you see from the statistics, the extremely low numbers of both interim and final protection orders. So, you know, while the police safety notices and interim protection orders are designed to provide temporary protection against domestic violence, until a survivor is able to obtain a final protection order. However, most commonly, police safety notices are used for protection rather than the protection orders, and this, shows the need, I guess, to ensure accurate information is disseminated to the public about protection orders, and especially how to apply for one. The other challenge is ensuring survivors receive assistance from police to apply for protection orders. In Section 16 of the Act, it requires that police not only serve the police safety notice, but also assist survivors to apply for a protection order. However, it is clear, I guess, from our experiences that this is not happening in practice. And it could be, police are not aware of the duties under the Act, and frequently they refer survivors on, especially within the referral system that we have in place, rather than personally assisting them to apply for an order. And most survivors are not aware of their rights under the Act, and rely on police to tell them about protection orders and or the police safety notices. Many women have poor experiences with police, or may face other barriers reporting to police. In the Solomon Island context, an example could be, the police officer is a relative of the perpetrator, maybe, or even very high cost of traveling to access police. The third challenge I want to highlight is, the lack of appropriate follow-up after interim protection orders are issued by authorized justices. So after authorized justices, that Ruby has explained earlier, has issued interim protection orders, they also face challenges, especially in ensuring that the police carry out their follow-up duties after the for the interim protection orders. So, since the authorized justices has been established, no interim protection orders that they've issued have been filed in court. There are challenges for police in serving interim protection orders, and not just interim protection orders, but also including the police safety notices and final protection orders on respondents, including polices themselves, not really understanding their role, and also police in Solomon Islands is severely under-resourced. And the fourth challenge I want to highlight is in relation to access to magistrates' courts for hearing of final protection order applications. So once an interim protection order is issued, it is very difficult to access a magistrate court for the hearing of the application for a final order. Accessing courts, the magistrate court is challenging here in the Solomon Islands due to the infrequency and inaccessibility of circuit courts outside of Honiara and regional centers. Between the commencement of the Act up to end of 2019, in fact, only one application for a final protection order was heard outside of the Central Honiara Magistrates Court. In terms of, I guess, the way forward for Solomon Islands in its implementation of the Family Protection Act, I think significant progress for us was that the Family Protection Act was reviewed in 2020. This was done through a comprehensive process of nationwide consultations, which was jointly conducted by the Ministry of Women, Youth, Children and Family Affairs and the Ministry of Justice and Legal Affairs staff, supported with a remote international consultant. And as we all know, last year within the COVID-19 context, I guess while initially we saw it as a barrier to conducting the consultations to inform the review, especially the border restrictions that prevented the international consultant traveling to Solomon Islands. This meant that the local staff from the Ministry of Women and Justice were fully engaged and upskilled to complete the consultations on the ground across all our 9 provinces, which was a positive thing for us, especially it providing the opportunity for us to especially develop stronger relationships, I guess, between the national and the provincial level partners that that we are working together to implement the act, and especially the relationship between the 2 ministries, the Ministry of Women, Youth, Children and Family Affairs and the Ministry of Justice and Legal Affairs. And so, the review, as I said, is key to us moving forward. The review report has made 42 recommendations that ranges from legislative amendments, the trainings for duty bearers, which also includes the police, increasing public awareness, recommendations around data collection, analysis and its use, including also recommendations on policy, research and development, but also reflection and learning from our experiences. In particular, the review recommends comprehensive training for police, the justice sector representatives and other frontline duty bearers, especially on their respective responsibilities under the Act. The recommendations from the review directly address the challenges just identified earlier in the previous slide relating to police training, regulations for authorized justices, and facilitating better access to justice for survivors. The Family Protection Advisory Council, which was established under the Family Protection Act, have approved the review report and have, overseen the development of an initial implementation plan with costing estimates. So, the report, along with the recommendations, the implementation plan for the recommendations and costings, we are looking forward to tabling this in Cabinet February next year. And this will be a joint Cabinet submission by the ministers responsible for women and the Ministry of justice. I guess this for us is a groundbreaking achievement for Solomon Islands. And you know, on this note, I would like to thank the Australian government through DFAT for the financial support they're giving us to enable us to conduct the review. As highlighted by Ruby, the Access to Justice project will continue and is now jointly owned and led by the Ministry responsible for women and also the Ministry of Justice and Legal Affairs. The project will continue to aim to conduct training for authorized justices, and we are, you know, aiming to at least roll this out to at least one province each year. But under this project, I guess some of the significant progresses is that so far we've, you know, the drafting instructions have been completed for the regulation for authorized justices, which define comprehensively the role of local court justices and the prescribed persons. Training for the authorized justices under the Access to Justice project and all training for duty bearers delivered by the ministry responsible for women and the Ministry of Justice. I want to highlight also utilizes the fundamental principles of gender and the human rights-based approach. So this is, you know, a critical part of all the trainings that we carry out with the authorized justices. One of our key aim is that we want to also see greater representation of women as authorized justices at the provincial level. As you know, this will also assist to facilitate access for survivors who may be more willing to speak to or seek help from other women. This project will, you know, aim to build on existing community resources and strengths and enhance community understanding of gender-based violence and how to respond. So, you know, through this, we aim to continue to create pathways for survivors to access the formal justice system through informal community systems that link to the formal system, especially through the local courts. Finally, the first years of implementation of the Act have shown that survivors use the Act to seek protection in ways that I guess work for them, which, as you've seen from the statistics and the trend, it is the temporary protection measures which is most utilized. So, you know, through our ongoing work to implement the recommendations of the review of the Family Protection Act and also through the Access to Justice project, we are seeking to enable women, especially those without ready access to the formal justice system, to access these protections. As you have heard, while we have seen some key progresses and achievements, we acknowledge that there is still much to be done. The review have also highlighted still a lot of learnings that we have to take on board, highlighted through the review. But, you know, the Solomon Island team, particularly the Ministry of Women, Youth, Children and Family Affairs, I guess we look forward to more of these kind of spaces, I guess, for sharing and learning from each other. As I said, my earlier presentation on the first slide, for us, the Act is still pretty much still a baby for us. And so, you know, always willing to learn and to see how we could improve, especially access to justice for women, especially in the rural and remote areas. Thank you.
Thank you very much to the Solomon Islands panelists. That was so thorough. It was really fantastic to get the detail of your legislation, but then to hear about your Access to Justice project and to get a sense of what you found out through your review and what you hope to achieve going forward. You'll see in the chat that others have also complimented you on a fantastic series of presentations. And I'd also like to thank Ruby for answering some of the questions that were in the chat as well, because unfortunately we don't have the time now to seek any further questions or comments as we have to move on to our next session. But thank you, and all the best in the future in the Solomons.